international law. International law. I will share my, yes. Yeah. Now we will discuss, or I will inform you about our syllabus and what is the overview of uh, public international law. Our topic, our subject is international law, but not all of the dimension of international law. We just want to discuss public international law. So it is part of international law. The other part is public international law. Yeah, I make slow because it is very basic understanding. In national law, the meaning of public law means hukum pidana. In domestic law, be careful. And private law is hukum perdata. Hukum perdata. But in international law, public international law is not equal with hukum pidana internasional. No. But pidana, or in English, we call it as criminal, just as a part of public international law. So the meaning of public international law in international arena is wider and more various meaning than in domestic law. But the meaning of private law, it is rather equal, but different issues. For example, private law in domestic affair means hukum perdata. Yes, in international law also hukum perdata, but different issue. For example, about marriage legacy pewarisan, or asylum seekers, or civilization, citizenship, business, contract law. Yeah, all these issues are in private law. What is the difference? Private law in national and private law in international. The difference is about the subject. Because in national law, the subject, they come from one nation. But in private international law, absolutely cross-border nationality. So the difference just the subject and the area of the law itself. But be careful about public international law because very different. One again, public international law in international law means not only criminal or pidana law, hukum pidana, not equal, but wider. What is the part of public international law? Public international law consists of several sub-law. First, what you call as hukum pidana. In international, there is international criminal law. Criminal means pidana. Criminal law. The second, diplomatic law. Diplomatic law. The law of the sea, hukum laut. Diplomatic law, hukum diplomatik. The law of the sea, hukum laut international. And now we call it as UNCLOS. UNCLOS means United Nations Convention on the Law of the Sea. Environmental law, border law, space law, the law of war, humanitarian law, human rights law. There are many public international law. So the meaning of public international law in international arena, not only hukum pidana or criminal law, but in domestic affair, absolutely. Hukum publik mean hukum pidana. This is in domestic or in national affair. But in international, there are various meaning. Okay. What is our syllabus? Yeah, this is our syllabus. Yeah, this is the general syllabus of our introduction to public international law. Meeting 1 and 2. Yeah, we discussed about the syllabus, the rule of the class, the aim of the international law, basic understanding and international and national law. Maybe our second meeting. And in this first meeting, I just want to discuss on the syllabus, the rule of the class, and overview on international law. Topic number 2. So topic number 1, we discussed in 2 meetings. And number 2, but the division on international law, public and private law. After that, maybe I can make more simple discussion in this topic, and I can change the subject maybe next to the topic number 3, subject and the source of international law, because it is more a long topic. The subject and the source of international law is a very long topic. Maybe I will make in 3 meetings. Topic number 4, the relation between international law and national law. I hope you remember in your high school, there is ratification process. Any one of you know or understand about what is ratification? What? Forget or don't understand what ratification? Ratification mean how to make international law. We apply the international norm, treaty in our domestic arena. So ratification kind of legalization of international treaty or international law to be domestic law or regulation. Yeah, not only ratification, accession and so on and so on. Next, we will discuss it. After that, we will discuss on recognition of state and government, ratification, accession, and so on. How important the recognition from other state for a new independent country, for example. Why there is a problem for a new country if they don't get recognition from other country? What is the impact? Maybe you sometime read in newspaper or in television, you see that there is a problem of recognition for Taiwan to be an independent state. Yeah, absolutely. They have government, president, ministry, and also army, but there is no significant recognition from other country. In other picture, you can see the Palestine government. Indonesia until today doesn't recognize Israel as a state or nation state, and Indonesia recognize Palestine. But generally in international arena, Palestine face a serious problem on recognition. So until today, Palestine not as a member of the United Nations, but Israel, very different. Israel joined a very strong government in United Nations, although just a small state. So there is a relativity. But in international arena, recognition still significant related to international law. International law. Because by recognition from other country, an independent state can be or to be as the subject of international law. So recognition is very important in international law perspective. But politically, sometimes there is a different perspective. And we also will discuss about the diplomatic law. The diplomatic law, Vienna Convention, about the protocol, additional protocol, and many treaties in diplomatic law. So I introduce you what the diplomatic law and several significant chapter we will discuss it. And in semester 6, I see, or semester 4 or 6, you will meet the diplomatic law as your specialist if you try to get more information and discussion on diplomatic law. You will meet this topic again in semester 4 or 6, I forget. And the last, I will introduce you about the law of the sea. Because the law of the sea is a very monumental international law. There is no national law on the sea. There is no national law on the sea. The only one, the law of the sea in international level. Because if you see the conflict between several countries in such an area, for example, in Natuna area or in many parts of the world, really because based on their national climate or regulation. So if this conflict or dispute bring to ICJ, International Court of Justice, the court will analyze this conflict or dispute under international law. So in the word, only the one in the only the law of the sea is in the international law. Indonesia is very in Indonesian perspective, the law of the sea is very important to unite our territory nationally, because majority of our map consists of sea of water. Now, our references in this discussion, firstly, I use the book from Professor Mokhtar Kusuma Atmaja. He was Minister of Foreign Affairs of the Republic of Indonesia for 3 periods in President Suharto era. He was a very prominent scientist in international law and the law of the sea. And he was the chairman of the United Nations Commission on the Law of the Sea at that time in 1980s, until the final conclusion and decision and the General Assembly of the United States. Really, the speaker was Professor Mukhtar Kusuma Atmaja, the Ministry of Foreign Affairs of the Republic of Indonesia. So he was very prominent intellectual and diplomat in Indonesia until today, that master the international law. So his book is very monumental. This is a simple book about the introduction to international law, pengantar hukum internasional in Indonesian. So I hope you can get this in internet, and I will try to upload the soft file of this book. The second book from Professor Burmauna. He was also a diplomat senior, ambassador, and influential scientist in international law in Universitas Pajajaran, and also in Ministry of Foreign Affairs. And also you can open the American Society of International Law in www.isis.org. So as maybe you want to update your current issues today, you can open this link freely. Maybe you register first, and after that you can free to go to the inside this web. Okay, this is the web. Yeah, this is the web of American Society of International Law. You can search in this web and get the update your information on international law. Now, this is what I said before about the division of international law. Firstly, about the public international law and private international law. Each law in international level has different headquarters, although in the same city in Den Haag, Netherlands. This old building, this is the headquarters of ICJ, International Court of Justice, under United Nations. This is it's like a church, the old church. There are many churches in Netherlands in medieval century, but today as official building. Sometimes university. And the second building is the headquarters of ICC, International Criminal Law. Absolutely or formally, this institution is not under the United Nations, but under international treaty created by several countries, more than absolutely more than 60 countries. So this building, a more modern building, futuristic and like German design. This is the new one as the headquarters of ICC, International Criminal Court, also in Den Haag. So each division of international law, public international law, the headquarters in Den Haag in ICJ. This is the building. and this is headquarter of ICC, or International Criminal Court. Okay. So before we discuss more and more about international law, what is really the meaning of international law? Based on Professor Muhtar Kusuma Atmaja, international law or hukum internasional is keseluruhan kaidah and asas yang mengatur hubungan atau persoalan yang melintas batas negara. So, all of the regulation and principle that regulate the relation and issues, conflicts, that cross the border. Between whom? Firstly, between negara dengan negara, state and state. State in this position as the subject of international law. Second, between state and the other subject of international law, but non-state subject. Firstly, state and state. The second, state and non-state actor. And in number two, really, there is two things. State and non-state. And number three, atau here, non-state actor and non-state actor. So, inside in number two, there are two things relation. Firstly, state and non-state, and number three, non-state each other. Okay, so the subject of international law in this definition under Professor Muhtar Kusuma Atmaja, hukum international or international law really all of principle and norm that regulate relation and issues or dispute among the subject of international law. They are state and state relation, firstly. Secondly, state and non-state relation. And number three, I give new number after atau. Number three, non-state actor and non-state actor. Yeah, because international relation today under modern international law is very different from international law in the ancient history. Because in the old century, international relation just between the state until the Westphalia Treaty. So next we will discuss the influence of Westphalia Treaty to international law, because today the international law we discuss in university absolutely refer to Hugo de Groot or Grotius, the lawyer and the expert behind the Westphalia Treaty. The conceptor in Westphalia Treaty was Hugo de Groot or Grotius. Also the conceptor of modern state or nation state. Or next we will discuss it. So in modern approach, the body of law that regulates the activities of entities possessing international personality. Entities, state or non-state, state or non-state. Maybe you are as political activist or the head of the political movement, maybe. For example, political movement leader in Papua, for example, maybe they declare the independence of Papua. You see this fact in the beginning of January 2020. They declare the independence of Papua or West Papua. But the leader and the government of West Papua to be the subject of international law or not, to be the subject of international law or not, it depends on many conditions in international law. So it is not easy to be an independent state. Yeah, need more effort to be recognized by other country and so on. So now we can understand that international law really regulate all of the activities and issues among the subject of international law cross border. So if there is Indonesian people, one person come from Bantul, one person come from Makassar, for example, and they stay in Sydney and the others stay in London and they make a business, it is not under international law because the citizenship of the parties still in one country. There is the different condition if the people of Indonesia in Sydney, for example, establish a private corporation or enterprise, for example, and the other person create also private enterprises in London, they will obey the in-country law, so not Indonesian law. But in public international law, if you have a certain citizenship, you should under your nationality. Okay. This is the old concept or traditional concept of international law. Just conduct or relation among the state. It is very old concept. But now, under Professor Mohtar Kusuma-Atmaja and the custom and practices in international law today, under the concept of Grotius in Westphalia Treaty, the subject of international law is not only state, but also the other subject of international law. Maybe you meet Freeport as MNC, multinational corporation. Or in the colonial era, there was VOC. VOC was an international law subject. Or maybe, yeah, McDonald, McD, and many MNCs in the world with a certain criteria, they will get the status of the subject of international law, but not all of. Yeah, there are many, many criteria. Okay. Maybe any question? Any question? If not, I want to go to our syllabus. That In this semester, we have 4 competency tests. Oh, electric off here, electricity off, but no problem. Uh, Competency test 1, 2, 3, and 4. And also we have 2 tasks. Yeah, 2 or 3. Maybe 2, maybe 3. And also quiz and forums.